everyone. I am Tracie Potts. I am the executive director of the Eisenhower Institute at Gettysburg College, and we are glad that you're joining us this lunch hour, or if you happen to be on the West Coast, it's a little earlier in the morning. We are going to be talking about the new Texas abortion law, the restrictions that were imposed in Texas. They have been in and out of the courts. There's been a lot of activity over the last few weeks, and we want to bring you up to date because just a month ago, this was the subject of our Constitution Day lecture, and a lot has happened since then. I will not be doing this on my own. I have two guests who know a lot more than me about this, and I'm glad to bring them into the conversation. And we'll be taking your questions. So if you have questions about what's been happening, how this works, please drop those into the comments. We are looking forward to answering your questions about this. It's been a hot topic all over the country, and so we want to take a little time this lunch hour to talk about it. Our guests today are Annie Douds. She is also with me here at Gettysburg College and the Eisenhower Institute. She works with our Women in Leadership program, our Eisenhower Scholars, and she is also a former federal attorney, longtime attorney, and she's been following this. Also joining us today, Upnit Bhatti. She is a managing associate with Orrick, but she also works with the Women's Bar Association of DC. Specifically, she oversees their amicus committee that actually has been working on some of these issues. So welcome, both of you. I am looking forward to this conversation. Annie, can you start us off just giving us a little bit of background so we all start out on a level playing field here? Tell us about this law. What's so controversial about it? What does it actually say? And how did it come about? Sort of a grassroots effort here, right?
Yes, exactly. Thank you, Tracie. Upnit, great to see you again. As you may know, the Supreme Court will hear oral arguments in this case 1 week from today. And that's essentially going to be about who can sue and who can be sued for what under the private enforcement mechanism of SB 8, which is what the Texas law is called. So by way of background, let's flash back to 2019 when an East Texas pastor named Markley Dixon was traveling town to town carrying his anti-abortion message along with a plastic toy fetus and some other props to local town council meetings. He met with like-minded local officials and drafted ordinances to ban abortions, to create what he called sanctuary cities for the unborn. Most relevant to this discussion, all of the ordinances that he lobbied for included a private enforcement provision, empowering private people to sue if they believed that someone had facilitated an abortion or intended to do so in the future. This private enforcement mechanism is important because it is the cause of all kinds of procedural consternation in the courts. Usually, enforcement of state laws is done by state officials acting on behalf of the government. If a person reasonably believes that a state law is going to interfere with one of their constitutional rights, they can sue that government official responsible for enforcement of it for what we call pre-enforcement relief, meaning they can sue and say, hey, Ms. Government Official, I can tell from looking at this new abortion law on its face that if you take action against me under it, you will violate my well-established right to access abortion care before fetal viability. So I'm filing this lawsuit to prevent you from even getting started on any sort of enforcement action. And that's kind of common. This new statute says that government officials are actually prohibited from enforcing SB 8. Instead, SB 8 says, hey, members of the entire general public everywhere in the whole country, you are welcome to sue people who aid and abet abortions in Texas. You don't have to, it's really up to you. But if you in your own independent wisdom decide to sue someone who helps someone else have an abortion that is otherwise totally illegal under federal law, we have it set up so that you are guaranteed to get at least $10,000 plus the costs and attorney's fees you incur as a result of bringing this totally optional lawsuit. Pastor Dixon got 37 towns to pass these kinds of ordinances. Someone tried to attack the private enforcement mechanism of the Lubbock ordinance in federal court in May, and the judge said in that case that he did not have the power to prevent hypothetical private people from filing hypothetical lawsuits. Pastor Dixon recently bragged that, quote, we have said from the beginning that this ordinance is completely bulletproof from pre-enforcement lawsuits. And so far, he's mostly been right. So after watching Dixon successfully float these legislative trial balloons in places like Lubbock, Impact, Cisco, and others, the Texas state legislature knew that the ground was fertile for state level action. In stepped state Texas Rep. Shelby Slauson and State Senator Brian Hughes, who sponsored HB 1515 and SB 8 in their respective chambers in March 2021. Governor Greg Abbott signed the law on May 19 to take effect September 1st, which is why we've been hearing so much recently. So what does this law say? First, basically, no one may perform an abortion after detectable cardiac activity, which usually occurs around the 6-week mark. Private people can sue a litany of defendants except the pregnant woman. The law does not require that the claimant have any connection to the person sued or be injured by the abortion in any way. The only people who are statutorily prohibited from suing are those government officials or someone who, quote, impregnated the abortion patient through an act of rape, sexual assault, or incest. Women can get an abortion after cardiac activity if there's a medical emergency, but not for rape or incest or for likelihood of fetal survival outside the womb following a full-term pregnancy. This is working out to be an empty provision though, because in reality, as of now, this is happening this week and last week, doctors are refusing to treat highly dangerous things such as ectopic pregnancies and other conditions for fear of being sued. There are no venue limitations, meaning a nurse working in Houston could be dragged into court by a plaintiff in El Paso. And last but not least, lawyers for the defendant can also be held liable simply for giving legal advice, which, by the way, is the subject of a lawsuit brought by attorney Michelle Simpson-Tugel, who you may recognize from the Nassar lawsuits. She sued at the end of August and won a temporary restraining order against Texas Right to Life, preventing them from suing her under SB 8. So there is some emerging precedent for success in responding to these lawsuits. A multitude of lawsuits have been filed in state and federal court about a myriad issues, and the MDL, the multi-district litigation folks down in Texas, have been working overtime to schedule and consolidate cases. But the two cases we are most concerned about coming out of Texas are Whole Women's Health versus Jackson and US v. Texas, United States versus Texas. So I'll give you a quick overview of those, and then Upnit, you can take it over.
So actually, Annie, let me hop in real quick here. So I just want to hop in so that people understand, because I know people have heard so much about this. People have heard the so-called Uber argument that maybe non-lawyers refer to it that way. The fact that people who aid and abet or assist with abortions, whether you drive someone to a clinic or however you're involved, are liable. So this, unlike what we have typically seen around the country, we've seen plenty of laws and attempts at laws when it comes to restrictions. But in this case, it's not the government suing. This is one of the key points. This is facilitating lawsuits between private parties, right?
Absolutely. Yes. And you are correct. The Uber, like Uber, not meaning macro, Uber meaning like Lyft and Uber services. Right. Yeah, they can be sued. So it's individual private people empowered to take on the responsibility of enforcing this law by suing anyone who provides an abortion, who drives someone to an abortion clinic, who advises someone about their medical options, who donates to a fund to support abortion care. We really don't know the limits of the potential defendants in this kind of litigation yet.
So let me put a hold on that other point, because I want to bring in Upnit to talk about where we've gone literally just in the last few weeks, all the way up to last Friday. There had been a plethora of developments in this case, and people who are outside the legal system, who are not attorneys, are probably getting whiplash, right? Going, what is going on with this? I heard that it was on hold, then I heard it was re-implemented, I heard it was in the appeals court, now the Supreme Court has taken action. Walk us through where this has gone and where it may be going next.
Absolutely. Thanks, Tracie. And thanks, Annie, for that very thorough background. I mean, every time I hear it, it's just like, wow. And as the court noted, I mean, at least in a sense, it's unprecedented. So ever since then, as the litigation sort of progressed to the Supreme Court, I'm going to cover that just because I think that's what everybody's interested in, knowing what's happening. So the court in an emergency order in what's known as their shadow docket. The shadow docket, let me just give a little blurb on that. It's an informal term for expedited rulings. So the Supreme Court issues these rulings outside of its typical process of hearing arguments. So there's not a thorough record, there's not oral argument. And in this case, this law was allowed to go into effect based on procedural grounds. So here the court noted that although there are some serious questions about whether the law violates the Constitution, the court nonetheless allowed the law to go into effect, saying, we don't know what's going to happen here. We don't know whether the anti-abortion activists who were sued or whether state officials can or will seek to enforce the Texas law. And as Tracie noted, Texas state officials aren't allowed to sue anybody. And so the court was like, we don't know what's happening here. And so let's let this law go into effect. And that was over dissents by 4 justices, Chief Justice John Roberts, Justice Breyer, Justice Sotomayor, and Justice Kagan, who authored very strong opinions saying, let's look at the situation in reality. In Texas, abortion clinics are shutting down. People are sitting there until midnight before this law is going into effect, knowing that these abortion clinics are going to shut down. There's an actual, harm being already seen here. And so we need to do something about this. At least we should have stayed this until we heard further things and the courts below ruled, but the majority didn't see to that. And so the law went into effect. But since then, since September, the government came in. The Biden administration filed lawsuits. In fact, the abortion providers that filed the initial lawsuit also came back to the court and said, can you please review this on the merits docket, not the shadow docket? Can you actually let things play out? Can you hear oral argument? Can you look at the records, see what's going on? Because Texas is in crisis. That happened. The Biden administration also filed a suit in the district court. The district court granted the administration's request to put the law on hold, but but the Fifth Circuit came back and said, no, we're going to temporarily put the order on hold, and we're going to reinstate the abortion ban until. So,
Upnit, I just want to break in here, and I want you to finish that, but I want to emphasize that point to people. The Supreme Court has not ruled on the merits of this law at this point. I think that's an important point to make. So the appeals court has, but the U.S. Supreme Court has not yet ruled on the merits, even though they sort of declined to get involved at one point. It's on what most people would consider a technicality or more of a jurisdictional issue, but that is part of what's to come.
Right, exactly. And so a lot of people are speculating because they're saying, well, if the court didn't even hear argument, does that mean Roe is overturned? Or is Casey overturned? What's happening? But I guess we'll see. As Annie pointed out, the Biden administration's requests were listened to. They filed a brief in October 18th asking for an emergency block of the Texas law after the Fifth Circuit ruled and said, Supreme Court, we need you to step in. This is different from when the abortion providers filed lawsuit. This is, the government coming in, and we have the right to sue. We have, standing is basically saying we have the right to sue, and that there's a lot at stake here. And just on Friday, we hear that the Supreme Court has granted that request. Oral arguments, as Annie noted, are a week from today on November 1st. So we shall see what the court will hear and rule.
And talk to me a little bit about those arguments. What are the arguments for and against this? What are the conservative arguments that we're hearing in favor of this law? And those amicus briefs, which sometimes are very revealing. What are we learning from those who believe they have a stake here and some input in this case?
Yeah, for sure. So the court will not only hear the government's argument and Texas's response, but also, as you noted, amicus briefs. Amicus briefs are briefs from the friends of the court. So anybody, and this is a very broad category, anybody who has an interest in filing a brief, letting the court know of separate arguments that the actual parties in the cases are not making, they can do so. And so we are seeing a bunch of arguments being made, and the court has the benefit of looking at those too. So let's go back to the administration's argument. They're basically saying this is not like the shadow docket case. Again, we have standing to sue. The government can sue when it sees that its laws are not being enforced. And based on, Supreme Court precedent with Roe and with Casey, Texas is violating those. And so we have the absolute right to step in. Texas is saying, no, you can't sue because the government is not getting an abortion here. So let's be clear of that. And then they're going back to their original argument saying Texas executive officials are not enforcing the law here. So I don't know why you're suing us. We're not doing anything. To which the government's reply is saying you're trying to thwart judicial review here. These are steps you're taking to make sure that you're not on the line because you're not doing anything. But in fact, Texas, you are doing something. And again, we have an obvious right to protect, anything that's nullifying for federal law. So those are the arguments being made by the parties. In terms of amicus briefs, there's a bunch being followed. There are a bunch that were filed. Medical associations have come up and said, you know, this law is an unreasonable interference in the physician-patient relationship. You know, as Annie noted, even though there are some exceptions in this law, physicians are backing out and saying, we don't want to be sued. You know, this is crazy. So they're backing out. It's also, you know, saying that this is interfering with physicians' due process rights, and it's abusing the court with just like frivolous lawsuits. And in terms of like training and stuff, even for medical residents, you know, they're going to have to seek out-of-state training programs to meet their training requirements in this field. You know, there are actual, you know, threats to medical students' education.
Well, and this is what is so important about understanding how these things work, because while it is still working its way through the courts, it is already having a realistic impact in Texas. People respond to what they think is going to happen. And so it may already be more difficult to seek an abortion. It may already be more difficult to get training to work in some of these areas. And it's, you know, aside from the legalities here, one of the things that's important to note is the impact of the law as it works its way through the courts, right?
Absolutely, and not just in Texas. In fact, other states have filed an amicus brief saying, you know, this law is, you know, unreasonable, not just for Texas, but it's also harming people in our states, because our people, our residents are, you know, not getting access to abortion because there's a large number of Texas residents traveling to seek care.
And are we seeing amicus briefs on the other side of that argument also?
Absolutely. So there are amicus briefs on the other side, and you'll see a lot more of those in the Mississippi case in Douds. There's a bunch filed in that case, which we can also review. In Douds, a lot of folks are saying, listen, somebody needs to protect the rights of unborn children. And the science has changed. The science regarding viability has changed a lot, and that cannot be the standard. A fetus is viable outside of the uterus at an earlier stage now. And given scientific updates and developments, we can't just keep changing the law. So Supreme Court, let us do what we need to do based on medical research and whatnot.
You know, that's an interesting argument, because we have seen that in other types of cases as well, with science and the law sometimes at odds, right? And the law, which was established sometimes many years ago, and we see the differences in scientific developments having an impact on that. Annie, I want to bring you back into the conversation with a thought and with a question. This is from Wendy on Twitter, who asked, what are the effects of this law on IVF, on cancer patients who find they're pregnant, on women who find a genetic anomaly several weeks in? And as you talk about that, I know one of the things that you've been concerned about is sort of the slippery slope of where this might go.
Yeah, so in response to the last part of Wendy's question, I think the Texas statute is pretty clear that a genetic anomaly would not be a reason to be allowed to get an abortion. It would only be a present moment medical emergency, not potential for problems with survivability or quality of life after birth. As for IVF and cancer treatment, we just don't know yet. And the slippery slope argument goes more to this private enforcement mechanism, because if we uphold the ability of private people to sue to enforce what is otherwise an unconstitutional law, then where does it stop? You know, what if here in Pennsylvania, we passed a law that said you can't say anything mean or ugly about Governor Wolf, and then you could have people suing to enforce that right privately, and, you know, in violation of the First Amendment, but since it's not a government actor, they're not subject to lawsuit. So it's almost like a be careful what you wish for, because I can't conceive of a limit on this issue as of yet. One argument is that people who are acting in this capacity are in fact acting under color of state law, which is one of the standards you have to meet in order to be sued in federal court over this. But we just don't know yet. I would like to add, though, Tracie, you asked about the arguments in favor. We should point out, in fairness, that these cases, the state of Texas is not saying you can't sue anywhere. They're saying you can't sue in federal court. They're saying you take this up in state court, please, where they think they would get more favorable rulings.
Gotcha. Thank you. Thanks for clarifying that. So, you know, as you brought it out, this is really interesting, because you have this what has historically been a very controversial issue. I mean, I remember standing on the steps of the US Supreme Court covering this. It has always been a controversial issue, but as you brought up, Annie, the whole issue of standing and who can be involved and who can sue is a really interesting legal question that's going to be addressed here. So Upnit, you mentioned Douds, you mentioned Mississippi. Talk to me a little bit about, particularly for people who may not be familiar with the fact that the Supreme Court is going to be taking up another case about abortion restrictions pretty soon, in just over a month, right?
Yeah, December 1st. So November 1st is this argument, and then Dobbs is December 1st. So this comes from Mississippi in a 2018 law called the Gestational Age Act. It prohibits abortions with a few exceptions after 15 weeks of gestational age. And here we have Jackson Women's Health Organization. It's the only licensed abortion facility in Mississippi. And one of its doctors filed a lawsuit in federal district court challenging the law and requesting that it be stopped until further litigation goes forward. There was a hearing. The lower court, district court, granted the order, or the temporary restraining order, while the litigation proceeded to discovery, which is, where all the facts and everything are shared by the parties, and things happen. After the discovery, the district court granted the clinic's motion for summary judgment and basically told Mississippi this is not enforceable. It was a very strong opinion. And so, and it basically found on behalf of, Supreme Court president, basically saying, we have law saying women are entitled to abortions, it's a constitutional right, you need to, get rid of this law. The Fifth Circuit, which is also the circuit court involved in the Texas case, affirmed. So this case went up to the Supreme Court, and we'll see what happens with that. Again, a lot of amicus briefs were filed in that case, a bunch. I can't go through all of them, but there's religious organizations arguing that we need to respect the life of the unborn. There are individual women actually filed briefs saying late-term abortions are harmful, and they're no longer needed, because in many of the states that have these laws, including Mississippi, they remove all obstacles of raising an unwanted child from every woman for any reason at no cost. So there are protections in place if you're concerned that you're not going to be able to raise this child, or you don't want this child, have the child, the state will protect you afterwards. And then also the argument about the viability line having shifted. There are states filing amicus briefs supporting the law. There are senators supporting the law. In fact, the Women's Bar Association and a bunch of other women lawyers and bar and national women organizations, this is the briefs that I worked on in the Women's Bar, with the Women's Bar Association.
I was going to ask you to tell us a little bit more in detail about the brief that you worked on.
Yeah, so we basically argued a couple of things. The main argument was the importance of precedent, the importance of American citizens to be able to rely on constitutionally guaranteed rights. Roe came out several years ago. We need to have something concrete. We need to be able to rely on what the Supreme Court has said and what has been guaranteed to us. And the second argument was, overturning Casey and Roe would curtail women's constitutional rights. And so the court will have the benefit of all these arguments and will weigh them. And the court does look at amicus briefs pretty seriously, and sometimes even, refers to them in the opinions and during oral arguments. So that case is scheduled for oral argument on December 1st. We shall see what happens. I wouldn't be surprised if rulings on both come around the same time. I don't know. We'll see. I'm not going to speculate, but
Is it going to be June? Is this going to be, the June 30th decision that we often wait on?
Well, the Biden administration's lawsuit that was filed in the Texas cases, that's an emergency request. So
okay.
Let's see what happens. But the Fifth Circuit is also hearing arguments on, I believe, December 7th in that case. So a lot of things are happening in the next month.
I would love to ask both of you, are there enough legal differences in these two cases to where we could see the US Supreme Court rule in one direction in one case, say in the Texas case, and another direction in the Mississippi case? Because that would be, in terms of setting precedent, that could really muddy the waters here, couldn't it? And set new legal precedent, but it could really confuse things. Oftentimes we see, Third Circuit says one thing, Fifth Circuit says one thing, and it goes to the U.S. Supreme Court for some sort of resolution. But is it possible here that they could give such different types of opinions? We don't know what they'll do, but such different types of opinion that it sort of confuses the larger issue even more?
I think yes is the short answer. The Texas cases procedural posture right now are such that it would be an indirect attack on the rights, constitutional right to abortion, because it's about who can sue and who can be sued. So one could envision a situation where in the Texas cases, they would say this private enforcement mechanism is an end run around constitutional rights. No, we don't think you should be able to do that, Texas. So perhaps sever out those clauses. At the same time, they could overturn Roe v. Wade with the direct assault through the Mississippi case.
Yeah, I think I agree with Annie. The cases are so different in terms of procedure. I get that the whole issue is Roe v. Wade. I mean, what's going to happen with that case? But the procedural posture, again, is so different. I mean, Texas has done something where it's allowing private citizens to sue. Now, I think the court will recognize that if they legitimize that, other states might follow and do that. And then I don't know what's going to happen in that case. But as the dissenters authored their opinions, as they said, Justice Sotomayor, Justice Kagan, Justice Breyer, Justice Roberts, excuse me, as they all said, we need to look at the substance of this case. Like, what is actually happening here? Hopefully that will be the center focus of the opinions. But again, given that emergency shadow docket order, where the majority just looked at the procedural stuff and didn't even get to the substance, there is a likelihood that, both of these cases could come out differently, because the Mississippi case doesn't allow, it's not based on private citizens suing. It's, it's
Yeah.
the law that,
kind of case.
Yeah, so they're different. They are.
Yeah. We have a question from Jen on Facebook, and I think you were kind of walking into this. Does giving the court jurisdiction to take any of these civil suits provide sufficient color of law?
I'm going to say yes, but that's because I think it was Dershowitz. Alan Dershowitz wrote an article about this, but I could be wrong. It might have been Tribe. So it's not my original thought by any stretch of the imagination. But there is a large group of legal scholars out there who are saying that if you invest the responsibility for enforcing state laws into private people, they essentially become agents of the government. And then they are acting under color of state law and then subject to lawsuits under Section 1983 and other proceedings. But I'm sure there are a lot of really strong arguments against that point. I just can't articulate them myself because I feel pretty strongly that they are acting under color of state law.
Yeah, I think I agree with Annie. I mean, I can only think of a couple of things where, the state's going to argue no. The statute specifically says no government officials can sue, or they might argue, well, that's, a bunch of people, and we can't control a bunch of people. How are you imposing this liability on us? It's just, we can't. But I think there are strong arguments about color of law. I think so. Yeah.
Yeah. So we've got maybe a minute and a half or so left. Anybody want to take a guess at how this decision may go? 5-4, 6-3. Very different decisions perhaps in Texas and Mississippi, and maybe the best guess, aside from the emergency declaration, is this going to be end of June, or might we know something sooner?
I think with the Texas case, we might know sooner, again, because of the emergency situation here. But in terms of predicting, it's hard. I mean, it's really hard. I think there are several ways this could go. Roe could be overturned, or the court could say, under the undue burden standard, which is, imposed by the Supreme Court precedent right now, they could say, well, this is in line with Roe v. Wade. There's no undue burden here. they could carve out some exception. I mean, there's so many ways this could go. And given what's been happening, the fact that the court is taking up the case again, I mean, it only takes 4 votes for the court to take the case. So it could have been the 4 dissenters. But we don't, I mean, it's hard to predict. It really is hard to predict, especially because I said before, and as Annie also noted, the Texas case is procedurally different, but now with the Biden administration stepping in and saying, no, we have the right to sue. This is different. I wonder how the court's gonna take that argument.
It'll be interesting. Anna, you get the last word. We're wrapping it up.
If I had to gamble, I'd say the Texas decision will come quickly and we won't hear about Mississippi until June.
I think you're probably right. Thank you both. Annie and Upnit, we appreciate you joining us and sharing your legal expertise and not only sort of walking us through the case, but walking us through what some of the real impact has been already. And that's something that's always important to take a look at. We have the law, but then we have the impact of the law and what's already happening on the ground. So thank you all for joining us. And we look forward to doing this more often. Lots of big issues out there, legal and otherwise, that are worth taking a look at. So thank you both. Have a great afternoon.
Thank you for the opportunity.